Thank you so much and welcome. Thank you all for coming tonight. We have never, in the short time that I've been here, we have never had standing room only in this room. So that is testament to Judge Sabatino's popularity and how many people have truly high regard for the work that you do. And you'll hear more about Judge Sabatino in a moment. It's my great honor to welcome you here to Rutgers Law School for the annual Weintraub Lecture. Tonight, we have a very special honored guest, and I have had so many people in the last 2 weeks approach me and tell me how excited they were for this event. And I think you can look around the room and see the evidence of that. There's truly a great deal of excitement to hear from Judge Sabatino. As I mentioned, you'll hear a full introduction of the judge in just a moment. But my role tonight is to introduce another very special member of our community, Zhao Sun. Zhao, class of 2011, is the president of Rutgers Law School Newark Alumni Association and a shareholder in the firm Orloff, Lowenbach, Steifelman, and Siegel, with concentration in business and fiduciary litigation. He is an extraordinarily skilled lawyer, and that's his day job. He also has another job for which we are extremely grateful. He's an ambassador for this law school. He's an enthusiastic and diligent worker on behalf of the law school, and Zhao is also a wonderful human being, someone who I can call and strategize with, and who is heavily invested in the success of this law school. He also brings a sense of humor to the work we do together, for which I am also very grateful. So without further ado, I'd like to introduce Zhao Sun.
Well, I was not expecting, nor do I deserve such an introduction like that. Oh my goodness. But anyway, good evening, everyone, and welcome to the 39th annual Chief Justice Joseph Weintraub Lecture. My name is Zhao Sun. I am the class of 2011 and the president of the Alumni Association, as the dean just said. And tonight I have the distinct pleasure of introducing tonight's lecturer, the Honorable Jack M. Sabatino, presiding judge, Superior Court of New Jersey Appellate Division. But before I introduce Judge Sabatino, I do want to thank Dean Bond and the law school for facilitating and co-sponsoring this event. I'd also like to thank Dean Steinbaum for his tireless efforts in organizing and marketing the event. And finally, a special thank you to Mark McHale and Patrick English, the co-chairs of tonight's event. I would also like to thank the many members of the judiciary here tonight. Your presence at the law school is always appreciated. So the annual Chief Justice Weintraub Lecture, it has long been one of the premier events of our legal community, and for good reason. Chief Justice Weintraub of Southern New Jersey, born in Cranford, grew up in Newark, admitted to the New Jersey Bar in 1930, where he focused, fittingly, given tonight's lecture, on appellate work. And doing a little bit of research, frankly, his ascendancy to Chief Judge was truly remarkable. Appointed in 1956 as a judge of the Superior Court, 6 months later, Associate Justice, and then by August of 1957, Chief Justice. And today we commemorate the legacy of Chief Justice Joseph Weintraub through this lecture series and through tonight's lecturer, Judge Sabatino. Judge Sabatino is a presiding judge at the Appellate Division of the Superior Court of New Jersey, where he has served since 2005. Prior to his appointment to the Appellate Division, he was a trial judge for 5 years, where he presided over hundreds of jury trials in the civil part and family part. And from September of 2022 through July 2023, Judge Sabatino also served in a temporary assignment on the Supreme Court of New Jersey. I didn't really know Judge Sabatino well before I was asked to introduce him, but I got a chance to speak with him and learn about him. And so one thing to highlight here is prior to joining the bench and continuing to the day, Judge Sabatino is someone that has always dedicated his time to teaching. In fact, not stated in your program is the fact that he taught at Rutgers Newark as an adjunct in the late 80s, teaching legal writing and civil liberty. So while this is not the school you were in, Judge, welcome back to the school.
Different building.
Different, nicer, maybe. And in fact, before his judicial appointment in 2001, he was an associate dean at Rutgers Law School in Camden. And in all, Judge Sabatino has taught at Camden for 25 years, about half the time, full time. And today Judge Sabatino continues to teach. Last year as a visiting lecturer on law at Princeton University, and he'll be repeating that seminar this year at the Eagleton Institute. So I've only appeared in front of Judge Sabatino once. We won. His recollection was we lost, but we won. Right. But he certainly has many, many admirers, as evidenced by this unbelievable turnout this evening. And I think what I've been told and what I've learned is he shares, many of the traits of Chief Justice Weintraub as a jurist. And in particular, I think it's this clear opinions on complicated issues, and that was really one of Chief Justice's Weintraub's, I think everyone looks back and says he was able to provide opinions that were easily digestible by lawyers, judges, and the public. As Chief Justice Weintraub famously wrote, "I like little words. They are spry, they dance, they paint pictures. I would not use a multi-syllable word when a four-letter word would do." And I think his point there is that one of the important goals of a jurist is to take a complicated issue and distill it down into one that anyone can understand. And Judge Sabatino is certainly someone with that quality. For that reason, I know we're in for a fantastic lecture tonight. We're honored to have you as our third night Chief Justice Weintraub lecturer. And without further ado, please join me in welcoming Judge Jack M. Sabatino.
Wow, good evening. Ciao for that phenomenal introduction. I guess I really can't hold a job very long. That's the problem. So Dean Bond, thank you for your gracious remarks. Chief Justice Rabner, boss. And federal and state jurists, both active and retired, who are kind enough to be here tonight. Rutgers faculty, I think I saw Ron Shannon. I've known Ron ever since we were both much younger. And I did teach at the law school building. And other faculty, students and administrators, fellow members of the bar and attorneys, I regard myself like you as a member of the bar. Friends and family and guests, and about 100 of you apparently who are watching this right now remotely. Thank you for being here. I'm just stunned by this turnout. I think it's maybe because a lot of you are Mets and Phillies fans. I don't know. My guys aren't doing so well either. I assure you, you'll get home in time if you want to watch the World Series. This will go about 45 minutes or so, and then we'll see if we have time for any questions. So this is not going to be a straight talking head lecture. Those of you who know me probably aren't surprised by that, maybe. This is more of a presentation, and there are going to be audio and video components. So if you're out there at home, make sure you have the volume up on your screens, and so you can hear what's going on. So this presentation is adapted from research I did as part of the Duke Law School Masters of Judicial Studies program, which I was lucky to be part of with about 20 other judges from many other states and federal courts and 2 judges from abroad. And my dear friend, Justice Fashali, who's here tonight, and I took that program together for about 2.5 years and learned so much. But one of the things that is required to get that degree is to write a thesis. So tonight is a presentation based on that thesis, which has a plug to my friends out there from Temple. It was published last year, late last year, in the Temple Law Review, and the citation is in your program. And so if you want to hear more, read more about what I'm discussing, you'll see it laid out there in more detail. And I do hope at some point to perhaps, if the law school approves it, to do a paper or some kind of shorter piece following up on tonight's talk. All right, So, next slide, please. And when you do something about video as your topic, of course, you have to make sure the video is moving along. And I'm so lucky to have Sue Perola here to help me through that. So we've heard about Chief Justice Weintraub. He served as Chief Justice from 1957 to 73, 16 years. I never heard myself compared to him, but I'm honored to hear that. So now a little disclaimer. Next slide. This presentation is not intended to convey any official policies of the New Jersey judiciary. Where's Judge Grant? I'm sorry. And not intended to forecast how any jurist here or in the future might decide something. All right. So a question for all of you. How many believe you were audio or video recorded today? And probably right now, many of you are on camera. Probably multiple times. Next slide, please. So the statistics on this are rather staggering, right? It's been estimated right now, there are at least 100 million surveillance cameras scattered around the United States, continually filming human and other activity. That figure is expected to double by 2027. So thinking about 200 million or more cameras, just the surveillance ones, and a population of 340 million, you can see that it's very pervasive. Another facet of it is whether those cameras recording us or microphones are automated or handheld. And some of the case law I'm going to talk about for a while looks at the operator and whether the operator was properly filming or recording what was going on, but now so much of it is automated at traffic lights and street corners and such. And we all recognize, next slide, that there's a wide variety of these recordings: surveillance cameras, police body-worn cameras, motor vehicle recorders mounted on police cars, Ring camera. Anybody know someone has a Ring camera? And many people do, right? That records people coming and going to your front door. Cell phone video or audio, of course, taken by private citizens. Recorded police station interrogations in most criminal cases involving serious accusations. Voice messages left on your phone, et cetera, right? So just an abundance of recorded material. And that can end up, of course, in court. And so let me just pause now and talk a bit about the history of how the law and the court system has responded to technological developments. So let's go first next with still photographs. This was something surprising that, the next slide. Here we go, thank you. Photography really didn't get developed until like the 1830s, right? And by the mid-1800s, by 1857, we have a reported opinion out of California where it was a boundary dispute and there was a photograph provided in evidence of an oak tree. Now, oak trees don't move, at least, so that made it a little easier, but it wasn't that blurry, I suppose. But that was significant evidence discussed in the court's opinion in 1857. And then 3 years later, in the United States Supreme Court, in the Luco matter, the Supreme Court discusses photographs of documents, land grants purportedly from the Mexican government, and inspected the signatures and the seals in those documents to verify whether they were authentic or not. They turned out not to be. So we already have there still photography making its way into both trial and appellate matters. Next slide. And then we can go to the early 1900s and see the impact of sound recording. So this Michigan case from 1906, Boyne City, a nuisance case brought against a railroad by a proprietor of a business, a hotel, who recorded the sound of the noisy trains rumbling past his premises to establish the nuisance. And this is discussed in the Michigan opinion as significant evidence. Less successfully, in 1912, you may, if you read about Clarence Darrow's career, he was indicted himself, right, in Los Angeles for tampering and other charges. And key evidence against him was recordings of eavesdropping of his conversations in his hotel room on what was called then a dictograph. There's a picture there of a dictograph. He eventually was acquitted, and part of his theme as defense was what an awful intrusion on his privacy these recordings were. But anyway, we now see in these two cases and many others now, the sound recordings are making their way in. In New Jersey, next slide, please, in State versus Simon, 1934, this is the pre-1947 Constitution Supreme Court, that Supreme Court, excluded a phonograph of a conversation on a dictograph, I think it's the same thing, that was hidden in a hotel room. Don't ask me why hotel rooms became the place to record people, but they did. And it was played in court on a Victrola. Anybody recognize a Victrola in that picture? And anyone recognize who's standing next to it? The famous opera singer, Enrico Caruso, who was not involved in the case, but it was a nice slide anyway. So what did the Supreme Court at that time in the 30s say in New Jersey? We know of no case, next slide, where a record of an alleged conversation was admitted as evidence. You can't cross-examine the recording, and such machines might be thrown in and out of gear. They were very dubious about the reliability or utility of such evidence. But then we fast forward to the Weintraub court, 1962. There's a picture coming up next, please. Justice Francis. In State versus Driver, I think many of the criminal lawyers in this room still use the Driver case, were cases with recordings. And there, the Supreme Court of New Jersey, the modern one, went the other way and said that the great weight of authority approves the use of sound recordings as evidence as long as it's competent and relevant and so on. And going to the next page, the Supreme Court announced, I'm not going to read them all from the slide, but announced various standards in Driver for the admissibility and use of the recordings, including, whether they were authentic and whether any modification or alterations have been made and the quality of the recording. So the next slide, please, it will show us that an obligation was imposed in the opinion upon the trial judges to listen to the recording outside of the jury's presence and decide whether it's sufficiently audible and intelligible, is it of considerable importance or relevance, and whether it contains any improper or prejudicial matter that ought to be excluded. Today, that would be under evidence rule 403, right? So the next thing that I wanted to show you about Driver, again, 1962, the recording was played for the Supreme Court. So as part of their appellate review process, they wanted to hear what was on the tape or on the recording. And they made their own assessment of it. And they thought, well, the voice of the defendant sounds weak. It's not really easy to discern. It doesn't seem like it added any real force to the state's argument about the confession being voluntary, should not have been received in evidence. So although the court endorsed the idea of this evidence being eligible for admission, particular case here and Driver found it to be inadmissible. All right, so that's the audio side of things. Now let's go to video. Next slide, please. By 1923, the famous evidence scholar John Henry Wigmore, in his treatise on evidence, was starting to refer to the admissibility of motion pictures. In Pennsylvania, and I know we have some Pennsylvania law graduates here, in Commonwealth versus Roller, 1930, the Pennsylvania court upheld the admission of a defendant's confession that was recorded on what was called then a talking motion picture machine. Now, mind you, 1930, what's happening in Hollywood at that time? The change from the silent era to the talkies, as demonstrated in the movie Singing in the Rain, which some of you may know, right? So this was all going on not only in Hollywood, but in real life and in the court system. Next slide. We also know that video recordings can be very powerful forms of evidence. And historically, we think about things like the 1963 assassination of President Kennedy and the famous Zapruder film that many of you have seen. On the right, also the 1991 video footage of Rodney King being beaten in Los Angeles. And then I don't have a slide for it, but we're certainly all familiar with the tragedy of George Floyd and the fact there was footage from both the police body worn cameras, but also footage taken by private citizens. So all of that can be quite evidential, not only in court, but in the public domain. Next slide I found very interesting. This is a 1960 New York Times article, which is cited by Justice Jacobs from the Supreme Court of New Jersey in a dissent of an opinion by Chief Justice Weintraub in Goldberg versus Newark Housing Authority. The question before the court was whether a landlord had a legal duty to protect tenants from potential criminal acts inflicted against them. And the majority opinion concluded no such duty should be recognized. Justice Jacobs dissented, but in his dissent, he cites, it's not distinct enough to see here, but this 1960 New York Times article about what was happening in a New York apartment building where surveillance cameras were installed in the elevators in lieu of elevator operators as a security measure. So we see how our court in 1960 was looking to this technology development as significant in the growth of law. And now I'm going to give you very briefly some statistics. Next slide. We did a little checking a few years ago, and in the appellate division in New Jersey between 2016 and 2021, which is a 5-year span, there was a 10-time increase in the amount of videos filed in criminal appeals. Now, some of that is due to the fact that prosecutors were beginning to, use body cam evidence more, and confessions or interrogations were being recorded more frequently. But a 10-fold increase, that's pretty dramatic. And all that coming in to the appellate division as part of the record, the evidence in the case. I didn't do a formal survey, but talked to folks in Utah and Michigan and Massachusetts, Ohio. All of them were experiencing a growth of this kind of evidence filed in appeals. Westlaw, from 2009 to 2023, what's that, 14 years? A 9-time increase in the amount of references and opinions to video evidence. So it's proliferating. It is very much part of our daily work now. So now let's reflect on what this means in terms of the pros and cons. Next slide. Let's think about the advantages, right? What are the pros? Well, we all want the judicial system to have a search for the truth, right? So we recognize that what's been recorded often can be an aid for that in that mission. It can be more definitive and more objective than the recollections or testimony of people, eyewitnesses who were at events. It's dynamic, of course. If it's a video or an audio, it's being played. It's not like a still photo. And subject to fairness concerns, it can be played or replayed or rewound, paused, and so on in a helpful manner. Now, I will flag, and I'm not going to comment at all about the merits of a pending Supreme Court case, only to identify its pending and argued. State versus Knight, the court is examining whether multiple slow motion replays of video evidence for a jury was permissible, or whether it can be done. There's some scholarship indicating that when you slow things down, it may suggest intentionality, either on the part of the defendant or if it's a self-defense case on the part of the alleged aggressor. So there are lots of issues we're confronting with regard to how the video is used and whether it's modified or slowed down or changed in some way. Disadvantages, next slide. You're all familiar with these things, but they become part of our everyday concern. Poor lighting, poor sound quality, the distance of the recording device from the subjects, fuzziness, poor clarity. They don't show us what happened right before, and they don't show us what happened right after. There can be breaks or gaps, which may have been deliberate, maybe not. it may be difficult to identify the people that are on the recording, the faces we see or the voices we hear. The possibility of confirmation bias, a very significant concern, is someone who's going to watch this video already made up their mind about what happened or who's at fault, who's in the wrong, and look at the video to see evidence that may back up their predilection. Does this kind of recording overshadow conventional proof, documents, testimony from the witness stand? Is it going to dominate it? We've heard about the CSI effect, right? The jurors now expect, well, where's all the bells and whistles? We see that on television. So there is a concern too that this might be too emphasized perhaps in the evidence as a whole. And the next slide is going to show us now, there's also concerns about the camera angle, right? If you have a police stop, and if you're filming it from the perspective of the police officer looking down, this is two different events, by the way, but just they were good shots. Looking down at the driver, you see, a sort of agitated looking driver who's maybe, done something wrong or is nervous. But then the next side of it, see the expression that the driver might see looking through the window of a cop leaning in, looking quite possibly intimidating. So that, again, the angles that exist on the films may be problematic. All right, next slide. Operationally, we're all trying to cope with this too. The courts, the lawyers out here. Frequently, we have situations where there was a recording, it was presented to the trial judge, and it's not been provided on appeal. We have situations with technology barriers because there's no uniformity among police departments. They use whatever vendors they've selected, so it's not the same technology from town to town or case to case. Private footage from surveillance cameras can be arranged through all sorts of companies. And when you have to access that stuff, sometimes you have to go through downloading a certain software that gives you access to that particular footage. It can be rather cumbersome and sometimes impossible. We now have a lot more concerns about authentication, right? How much of this is real and how much, if any, has been fabricated through the use of artificial intelligence? That's going to be an issue we'll be confronting more and more, I'm sure. A pet peeve of mine, the briefs may not really cross-reference where to find this particular event. I've got a time counter here, this footage. I had one recently. It was a robbery of, I won't tell much detail, but it was a robbery of a retail store. There were 12 separate cameras, all of them filming it for about 20 minutes. And the briefs didn't say where to look. Now, a good advocate would point that out to you, right? But sometimes they don't. And all of that translates into what? Extra time and effort spent, not only by judges, by the court staff in getting this stuff filed and managed and provided to the judges. Next slide, please. Going back to the Weintraub era, State versus Kosoliak, 1957, has this wonderful quote. And actually, this was a case in which Weintraub was actually an associate justice. He briefly served in that role. I see Chief Justice Zali, my friend here today, who is one of the rare people who had served both as an associate justice and as chief. Weintraub, in this case, was on the court and in the majority, where they point out verbal precision. What words were said, what words were in the material can be so important to the meaning. Did the person say would, or could, or should, right? Those are nuances that become very important to judges and lawyers in handling appeals, but we want to get it right? And therefore, the importance of verbal precision not only carries over to documents and testimony, but maybe also to recordings. How many of you have heard of or seen the movie Casablanca? My favorite, right? I know Judge Karchman knows that well. And we'll talk about that later. Casablanca has a quote that people frequently attribute to the movie: "Play it again, Sam." No, don't speak out yet, but some of you may think that that was never said in the movie. Some of you think it was. Well, as somebody who used to be a New York sportscaster said, let's go to the videotape. Let's see what happened and what actually was said, because verbal precision matters. Next slide. Here we go. And we can, yeah, that's how we started right there.
I grab Ugarte, then she walks in. Well, that's the way it goes. One in, one out. Sam.
Yes, boss.
It's December 1941 in Casablanca. What time is it in New York?
What? My watch stopped.
I bet they're asleep in New York. I bet they're asleep all over America. Of all the gin joints in all the towns in all the world, she walks into mine. What's that you're playing?
Oh, just a little something on my own.
Oh, stop it. You know what I want to hear.
No, don't.
You played it for her, you play it for me.
Well, I don't think I can remember.
If she can stand it, I can. Play it.
Yes, boss.
Video evidence we just heard demonstrates. He never said it. In fact, nobody in the film ever said it. Ingrid Bergman didn't say it. She said play it too. All right. So sometimes you have to go to the source. One of the problems we've encountered sometimes is that the soundtrack created from a body cam is not necessarily accurate. It might misidentify who was speaking. It might not transcribe portions of the conversations that could be important, and sometimes call something indiscernible when it really is. And we actually had this experience during the 2023 term in the court, where we actually remanded a pending case because it appeared through the close examination by one of my law clerks that it appeared that the transcript wasn't matching the video. It was a case involving a search of a trailer, and whether or not, excuse me, the people that let the police in had apparent or actual authority to search inside where they found guns belonging to the defendant. So here's what the transcript says. Next slide. All right. But this tells us we had a limited remand. Straighten out the record, please. Next slide. The question is, whose property is in the trailer? Now listen very carefully to what you hear.
You got property in there too?
Yeah.
Okay, we'll do it again. The transcript says he, meaning defendant, he's got property, and that's what was in the official record. Listen again.
You got property in there too?
Yeah.
If you hear it closely over and over, it's a you, not a he. A critical distinction. All right, next slide. Another thing that came out was some of the parts of the official transcript indicated unintelligible, indiscernible. Listen to the response that's given to the officer's question about, do you have stuff in there? Go ahead.
You keep your stuff in there also, right?
Hear it again?
You keep your stuff in there also, right?
All right. She's saying something, and it sure sounds like, it sounds like she's giving agreement. It's much more complicated and it's indiscernible. All right. Another thing about this, next slide, was the question of whose shoes. Let's watch a bit of as they're walking along with the officer and take a look. Pay attention to the footwear. Becomes important.
This one.
The footwear.
This one. Oh, yeah.
She in there?
No. My sister?
Yeah.
She went to open up the shed.
In here? What got in here?
It's already been opened.
You guys keep stuff in here, right? Oh boy.
And then they found the bag with the guns. All right, so the transcript identified the woman who was speaking to the officer as the victim. And that person says, my sister unlocked the trailer. Notice the speaker was wearing blue shoes, dark blue shoes, with no socks. All right, next slide. But when we met the victim earlier, she's not wearing shoes, she's wearing sneakers, black sneakers with striped socks. The transcript is wrong, even though it's the official transcript. Wardrobe change? Or maybe just an error in the transcript. Now, I don't want to be harsh on transcribers. It's a very difficult task, especially if you're not in the courtroom and you're doing it after the fact. But the point is that we are discovering on close examination, many of these recordings, the transcripts are not meshing with what's there. We had a circumstance, next slide also, it's now, next slide again, please. The official transcript is one that's created when something may be played in the trial court courtroom. But in some instances now, police departments or prosecutors are taking the footage and sending it out to a private agency and having it transcribed, turning that over in discovery. And that becomes a transcript that the lawyers are using as the case is being litigated. So in the next slide, this one, we had a situation where on the left, you see the official transcript, because this was played in the courtroom, and it's all unidentified male, but they really aren't able to specify who's speaking. And this was a discussion that the individual was having with police who had come to arrest that individual. And he was concerned about earlier on whether he was being recorded by the police. So the transcript says, are you, present tense, are you mic'd up? But when you go back and look at the unofficial transcript that the lawyers had worked with, it was were. Before, were you mic'd up then, which became a significant issue in the case. So we sent that one back too. And so please settle the record. Are we relying on the version that was played in court, or are we relying on what was procured during the discovery period? The parties agreed, go with the version that was procured during discovery, because that's more accurate. All right, a little music. Next slide. Appellate review of audio evidence. Next slide. I don't know if any of you have ever heard of Ira Arnstein. He was a composer who wrote songs in what was known as Tin Pan Alley in the 20s and 30s. And in ensuing years, he brought a lot of copyright infringement cases in federal court against famous artists for, in his view, infringing on his melodies. And in this particular case, he sued Cole Porter. And Cole Porter has a song, which some of you know, Don't Fence Me In. Arnstein said that's an infringement. So the district court granted the defense, Cole Porter, summary judgment after hearing the comparison of the recordings that there was no triable issue of similarity. All right, let's play the first side. You can hear a little bit of Modern Messiah. Okay, and Don't Fence Me In. Okay, let's stop it there. How many of you hear some similarity between the two tunes? A little bit? All right, let's isolate it down to 5 notes, a little bit more than the measure. Next slide. Cole Porter.
And under starry skies above.
That's Bing Crosby, by the way. Do it again, that same one, please.
And under starry skies above.
Okay, and now Arnstein. So if you isolate that one passage, the similarity in that portion of a much longer piece becomes maybe more apparent. So what did the Second Circuit Court of Appeals do? It split. Next slide, 2-1. Judge Jerome Frank, joined by Justice Learned Hand. Some law students here, you might be familiar with Learned Hand, right? The two of them listened over and over, and they even got their staffs to listen to it. One of them contacted the Yale University organist, wouldn't do that today, to get an opinion about it. And they said, well, the similarities are sufficient that a jury might properly infer infringement. A jury might. That's the majority of two. Next, though, we have Judge Clark, one of the fathers of the federal rules of civil procedure, by the way, who says the opposite. After repeated hearings of the records, I could not find therein what the others found. And he would advocate to affirm summary judgment. So the case went back. If you're curious, it went back, was tried before a jury, no cost. So that didn't turn out so well for Mr. Ornstein. But what this rather famous case shows you, though, is even back in the 40s, there was strong disagreement among the appellate judges about what was or was not on the recordings. All right, now we go to video. Of course, we have all sorts of devices these days. Let's go to Scott versus Harris. How many of you know Scott versus Harris? It's now taught pretty much regularly in Civ Pro classes in law school. So in Scott versus Harris, we have a police chase of a driver who allegedly is engaged in very dangerous conduct, driving away from the police. And eventually, the police officers followed him and rammed the back of the car, severely injuring the person they were following. And he brought a Section 1983 civil rights action claiming excessive force. The state argued that, or the defendants argued, they had qualified immunity for that on that occasion. So a lot of it was, how dangerous was the driving? Justice Scalia writes the majority opinion in an 8-1 case, concluding that the driving was so dangerous it justified the police action. And he says right in the opinion, we're happy to allow the videotape to speak for itself. So even though, next slide, the district court, and next slide, the 11th Circuit found a triable issue in front of the jury, the Supreme Court of the United States majority said this driving was so dangerous that there's no way this case should be presented to a jury. And we'll look at a segment of it here and see what you think. Okay, you get the general idea. Now he's really going fast. Okay. Manipulation. Anyway, that's what he says. That this is resembles pretty good wild horsepower. The most we're going back up 74. And during our oral argument, next slide, he says, next slide. Yeah, he created the defendant or the plaintiff, the scariest chase I ever saw since the French Connection. Wait. Let's go to the videotape. Let's see the evidence. Famous scene, right? Famous Hollywood scene. That's how you get the Yankee Stadium, by the way. Oh, no. Now, all alone, Justice Stevens, he watches the same footage and comes up with a totally contrary conclusion. He says, the guy used his turn signal at various points, stayed in his lane most of the time, slowed down. This is hardly the stuff of Hollywood. I dissent. And we watch a little bit of footage that he was focusing on. Stop it there and go on to one more justice who joined the majority, and that's Justice Breyer. Justice Breyer says, because watching the video footage made a difference to my own view of the case, I suggest that an interested reader take advantage of the link in the court's opinion and watch it. And here's how this sadly ended.
All right, take him out.
Why don't you go back? Here we go. All right, about here. It caught up to him.
Still, he's been on the TDK Boulevard, 6 units full, went to 4C.
And they hit him.
100, this 250, that's gonna be a bad 1050 bag. William, get them to start aim with 1018.
So here we are. So the question again, the appellate court divided, reviewing directly the video, has different takes on what they saw. Right? Now, let's tie it to what we do in our own courts. What standard of review of trial courts when interpreting facts shown on the video? The analogy that we all, many of us are familiar with, of course, is the instant replay in sports, where there's a referee or umpire makes a call on the field, and there's a request to immediately review it, watch the video, see what the thought is. And in sports, whether it's basketball, hockey, soccer, the general standard is what? Is that we don't interfere with the call on the field unless the video clearly shows there was a mistake, right? That's the standard we have in many states and in New Jersey. There's opinion by Justice Alban, who I believe is watching. Hello, Justice Alban. In State versus SS from 2017, establishing that the appellate court should not reverse or set aside a decision, and some people are nodding that have to deal with this case a lot, unless the video or audio shows the decision made below was clearly mistaken or clearly erroneous. At last check, over 600 decisions published and unpublished have cited SS, and about 240 on this very point about the standard. And we've had some cases since then at SS where even given that standard, that's been found on appeal that the ruling made below was just clearly wrong. And in others, just the opposite. If it's ambiguous or it supports the judgment below, then we're not going to mess with it, of course. But don't give blind deference just because somebody was the fact finder. If you look at the evidence yourself on appeal, you've got to at least bear in mind that sometimes a clear mistake can be made. Clear mistake was made apparently earlier this year. And the appellate division, my part, not me though, my part was involved in not taking any credit for this. Next one, please. Here we go. How many of you heard in the press about the semifinal game, boys basketball, high school, between Manasquan and Camden? So Camden, just to set it up, Camden made foul shot that put them in the lead with only a few seconds left. And the Manasquan player takes the ball down the court and a shot is attempted and another shot is then made. And you can see what happens here if you saw it. Here we go. There's Camden. Make the shot. 5, 4, 3, 2, miss, up, Now the rule in basketball, if you don't know, is as long as the shot's in the air while there's still some time on the clock, it's good. The referees huddled and said, no basket, time it expired. And this it went viral, right? Everybody that had some interest in sports saw this around here. So what happened? The results stood. The rules of the sport were once the referees leave the court, it's over. No further appeal. But they tried anyway. Manasquan went to the Commissioner of Education, who denied intervention, and then went to the Appellate Division Emergent Panel with Judge Marsick and Judge Muller, who might be watching, and they also declined to intervene. Now, the happy end of sorts to this is, even though the game result wasn't changed, yeah, clearly erroneous, the Manasquan kids and their coach and the Camden kids all went to the finals, and the Manasquan kids rooted for the Camden team. That's sportsmanship, right? But I show you that because inevitably we're going to get it wrong, right? The referees here got it wrong. Maybe a judge or an administrative law judge got it wrong. It's going to happen. So what do we consider then as pertinent on appeal? And this is the last part of my talk here. So go ahead. First thing, how conclusive is the video evidence or audio evidence in either confirming or undermining what was decided below? How conclusive? Second thing, how material was the mistake? And third, what context procedurally are we? Are we in a civil case? Are we in a criminal case? Are we in a suppression motion or a bench trial in civil, or are we in summary judgment territory? Because that may affect how we regard either an ambiguity or a conclusiveness shown by the video. All right, so let's move on with some suggested tools, which are in the article if you want to reference it. So the first thing I've proposed is, if it's warming up here we go, a model rule. And even though this came out last year, no state has adopted this model rule yet. I don't think so. All right. But here's a few ideas, defining, of course, what it is. The technology should be compatible with the court system and with what the other side uses. We should know the date, the time, and the source and place, and what exhibit numbers, next slide, relates to. If we get so much of this stuff, maybe just as we have limits on the number of pages in the brief, the number of minutes or hours of footage might at some point be presumptively limited, perhaps. In the briefs, they should cite exactly where we should be looking. And we just did this actually, this part F in revising Court Rule 1:2-2. Now, if there's a video, the soundtrack of the audio should be transcribed. And also if it's been enhanced or altered in some way. There's all sorts of digital technology that I don't fully understand that ties in with that, but there are concerns about enhancement. So that would be a model way, first of all, to make sure that we get the record provided in a usable way. The next thing I've provided here, and you'll see it in the article, is a checklist. If you or your associate or your law clerks or colleagues are looking at video, some reminders of things to look for, right? Was it admitted or tendered? Is authenticity a question? Next slide. Was it played for the jury? Under what circumstances? All this becomes the kind of things, next slide, that we look at. Camera angle, lighting, all that. So that's something that could be a useful tool if anybody would like to share that with the people they work with. The third thing I want to present now, because it's an academic article, you have to have a chart, right? So here's a chart. Here's a chart with some things to consider. So on the left, you see the various possibilities, right? The digital recorded evidence confirms the trial court. Well, no surprise, affirm all the way through, right? Because that's not at least going to change the outcome because it's consistent. But what if it shows a discrepancy that's not consequential? Let me throw out this example, which is mentioned in the article. Let's say it's a motor vehicle stop by police, and there's a suppression hearing to exclude evidence that was recovered from the vehicle. And the trial court hears testimony from the officer who took part in the search, who testifies under oath as follows. Oh, I approached the vehicle from the passenger side, and my gun was definitely holstered. It was not drawn. And the judge says, in her opinion, I find Officer so-and-so to be very credible, and I'm going to accept that as what happens. Right, but what if the video shows, and we can find out on appeal, the video shows that the police officer approached the driver's side, and the gun is clearly drawn. Is that automatic reversal? Well, it depends, right? What's the issue in the case? How consequential is it? If the issue is, was the driver intimidated by the officer to provide consent to search the vehicle, then that mistake sounds like it's a pretty important one, doesn't it, right? But if the issue in the case was very different, it was, well, whether they had, based on their observations of the motor vehicle movement, reasonable suspicion to stop the car. Well, you caught the officer in a misstatement on something, but that's not really central, as central as what I just described. So it's not just the aha moment and showing the video is contradicting something below, but is it consequential? So that's why I have that on the left column. If it's ambiguous, for example, bottom left, and summary judgment was granted where the judge said, oh, the evidence is so clear, no genuine issue of material fact, but then you look at the video or hear the audio and it's ambiguous, and you've got to wonder, is it that lopsided, right? So those are some of the considerations to take into account. Next slide. Essentially, as we go through this, technology, as you've seen, can affect the law, can affect trial court proceedings, and it's certainly now affecting every day the traditional way we go about appellate review. And no longer are we just reading briefs and looking at documents. We have to be good listeners and viewers as well. So that's my point. Probably an obvious one, but I hope you enjoyed what I presented. I want to acknowledge and give a shout out to a number of people, I have several of my law clerks here. Would you please stand up? The law clerks are here today. I'm embarrassing you. Come on, stand up. This is not even a quorum. I've been a judge 24 years. I have 40 law clerks, but several of them worked on this research and they were very helpful, including, I want to shout out Rob Bendeluski. Rob helped put these slides together about a year ago. I also should acknowledge my Duke faculty advisors, folks out there from the Temple Law Review, the thoughtful scholars, colleagues, and friends who gave us ideas, librarians, Kathy Spalding, Peter Egler from the University of Pittsburgh, the appellate division, staff and IT team. Let's hear a shout out for Sue Parola, who's done a great job today. Rutgers Law School and Alumni Association, and my longtime friend, Dean Rob Steinbaum. Where's Rob? There he is. He's down. Anyway, I know there's food waiting for us upstairs, but should we, any suggestions?
So everybody who's a friend or a judge is invited to dinner. It's upstairs on the 3rd floor. Take the elevators outside of that room. Bathrooms are in the corner, the opposite corner of every floor.
All right, I'll take a question or two if you, on the last thing between you and dinner, I know. Anybody want to ask a question or make an observation? All right, hearing one, I think we are adjourned. Thank you very much.